And it's working. Okay, great. Now we can start the webinar. Okay, good afternoon, everybody. I hope everyone is doing fine. I've got to say it's a true pleasure for me and for Edp Belgium to welcome you to this new webinar. And today we're going to talk about a very, very hot topic, since we're going to talk about tracing systems. And to discuss those systems with us today, we have Alexandra Jaspar from the Belgian Data Protection Authority. Mrs. Jaspar has been studying at the French-speaking University of Brussels, the ULB, before going to Northwestern University, Chicago, and working as a data protection lawyer in Linklaters. She then became director of the compliance department of bpost, which is the post office department of Belgium, and then becoming member of the Data Protection Authority as director of the Knowledge Center and president-elect of the Data Protection Authority. Mrs. Jaspar, welcome. Would you like to say a few words?
Yes, welcome. I just want to make sure everybody can hear me. I hope so. It seems to work. Thanks for the introduction. It's perfect. I'm glad to join as well. I'm eager to tell you what I know about the tracing system in Belgium and our advice in relation to this.
Thank you very much. And you're especially skilled in the topic, since you have been the one studying all the different projects that have been submitted to the authority in Belgium, if I'm right.
Yes, well, I work with a team, and we started working with 2 other people on those projects, but at some point it became so, well, we were receiving 1 project a day that I decided to take the lead and to centralize all of this. So yes, I've been following all the 7 projects on which we've been providing an advice so far, which makes that I have a helicopter view on all of these and can tell you a bit of everything about each of these projects.
Okay, great. All right. So I propose we jump to the presentation. Okay, so starting with the presentation now, what are we going to talk about? So we're going to start with a small introduction on the topic, talking about the whole framework of those tracing systems. Why are they being discussed at the moment? What is complicated about them, etc. Then moving to the legal framework that those systems have to respect. Then we're going to move on to which tracing systems we talk about, since in Belgium 2 kinds of systems are being discussed with their specific rules that are going to be presented by Mrs. Jaspar. And then she's going to give us a few words about her assessment of each system as a member of the Data Protection Authority. And I will be talking very fast about the guidelines that Edp Belgium has been drafting and sending to the Belgian authorities. We'll finally go to the conclusion and to the Q&A session. For those who might be following us on Facebook, please know that those questions we're going to take are only going to be those on Click Meeting. So for those of you who would like to ask some questions, you can join us on Click Meeting by clicking on the link that has been shared on the Facebook event. All right, so to start with the introduction, what are exactly tracing systems that we've been talking about so much? The fact is that, as you probably know, I guess, we're in the middle of a pandemic which imposed us to go through a big lockdown. The reason of this lockdown is that this pandemic of COVID-19, this virus, this specific virus, spreads very fast between individuals, and thanks to contacts between individuals. This is why it was needed at first to impose a lockdown which would prevent having too many contacts between the people. And now that we're slowly reopening our countries and economies, the question is how to control the pandemic so that we do not have a second wave, so that we do not have to enter a new lockdown. And the 2 main answers are being brought, which are first, putting into place a very broad campaign of tests. And the second one is tracing people, tracing the contacts between the people to be able to, let's say, prevent the people that might be infected and organize a proper follow-up of those specific people without having to block the whole country once again. This is the main reason behind those tracing systems. But the fact is, the question is, why are there so much discussed? What is so important about them? Why is it so complicated to put them into place? The fact is that since they require the processing of a quite big amount of data, they might be pretty risky and pretty dangerous. And this is why so much is being studied and said about them. And the second reason why they're being discussed so much is that they have to respect a quite big amount of rules. Since here in Belgium, we beneficiate of one of the broadest protection, which is the GDPR, General Data Protection Regulations, as well as a certain amount of other regulations, which those systems have to respect in order to be put into place. And this is why this subject is so fascinating and so opening so many debates. And in my eyes, the reason why we talk so much about them is that it's unprecedented. It would never have been possible to put that into place. We don't have the needed technologies before, the needed framework before. And this, today, it's kind of a new test for these new technologies and legal frameworks that we have today. So this is why this debate is so important and must be discussed. Now that this has been said, maybe let's summarize a bit. What are those rules I've been talking about that are applicable in Belgium? So as I mentioned, and as most of you probably know, Belgium is a member of the European Union, which means that the General Data Protection Regulation is applicable here. Not only this regulation, of course, but also the data protection law, the privacy law that has been put into place to implement the few elements that were not harmonized by the GDPR. With this framework come a few other texts, such as the Convention of the Council of Europe on protection of personal data, as well as the e-privacy directive and the law implementing it. And something worth mentioning is that Belgium is a constitutional federal state, which means that to make it even more complex, we have different layers of powers. We have a federal state with regions and communities which have their own competencies. For example, the regions are competent for fighting against diseases and viruses, while the federal state is competent for privacy regulations. And all this makes it very, very complex in Belgium, and this is why it's even more interesting. And lastly, one last important regulation we can talk about is that creating the Belgian Data Protection Authority. And this is where I'm going to let the floor to Mrs. Jaspar, who's going to present us the authority.
Thank you, Victor. I'll move to the next slide and show you what the Data Protection Authority is all about. It's very specific to Belgium, so don't believe that all the protection authorities in Europe are construed like ours. We are 5 directions within the authority. You can see those on the slides. And just to give you a very short word on each of those directions, what do we do? We first have what we call first line service, and the first line service is in charge of answering questions from citizens or undertakings, for instance, in charge of managing complaints, making the receivability check. So is a complaint acceptable and shall we proceed with this complaint? And also in charge of awareness raising, so launching, for instance, campaign aiming at promoting data protection in general, or at informing people that they have rights and that they should exercise those rights in certain situations. We also have, and I move to the yellow block, a general secretary department who is in charge of, for instance, reviews what we call DPIAs, so impact analysis, also in charge of managing and revising code of conduct, for instance. We also have an inspection service, because perhaps you know that now, since the GDPR is entered into force, we have the power to impose sanctions, and that's all new. And we've been using that power since 2 years, as you may know. So what happens when a complaint, for instance, is receivable? It goes to the inspection service, and our inspection service leads an inquiry. It has all kinds of powers to lead that inquiry and submit its report to what we call the litigation chamber. The litigation chamber is like an administrative court, so in-house tribunal, who has the power to impose, for instance, fines or cease and desist order and this kind of things. So that's the chain from a complaint to inspection and then a litigation. And perhaps interesting for you also to know that we as a direction committee, we may also ask the inquiry service to lead an investigation when we detect, for instance, something which seems to be a violation of the GDPR. So it's a kind of ex officio proceeding that we may launch. Next to these 4 directions, there is the one I'm leading, which is the Knowledge Center. And the main task of the Knowledge Center, I move to the next slide, is to issue advice and recommendations. A recommendation is a general application of GDPR to specific situations or sector. For instance, we've been issuing it's already 3 months ago, a general and very wide recommendation on direct marketing. So we've been applying all the principles and concepts and rules of the GDPR to the situation where you want to send an emailing to your customers or to potential new customers. We've been addressing questions such as the purchase of data, profiling, on all these kind of techniques. So that's a very general way for us to clarify how the GDPR should be applied by either undertakings, authorities, citizens, to a specific situation. Now, besides these general recommendations, what we do the most, so that's really the biggest part of our activity at the Knowledge Center, is revising draft bills. So draft laws, draft decrees, draft what we call in French arrêté, and all normative or regulations, normative text or regulation from the authority, aiming at or just creating data processing. So as soon as the regulator would like to create, for instance, a new database or organize a new service who will process personal data in the sense of GDPR, it has to be foreseen in a law or in any normative text, depending on the importance of the intrusion in the people's life. And we have to review those draft texts to make sure all principles of GDPR are compliant with. And the general idea behind this is, of course, that we are not entering into a state where the state entities have all powers and can do basically what we see in China, for instance, or in some other countries where people have no more freedoms, no more liberties, and where the state has all powers to do basically everything that it wants with personal data of citizens. So that's the main purpose of our review. I'll move to the next slide. Up. No, that's not the one I want to go to. Yeah. Generally speaking, what do we do when we receive such draft, let's say draft law? What do we do? What is a review? How does it take place? First, we check, of course, that the text, the contemplated data processing relies on a legal basis. So I guess you all know that any processing of personal data should be justified by one of the situations which are mentioned under Article 6 of the GDPR, and in some specific circumstances under Article 9. That's where we process sensitive data, so health-related data, or for instance, data related to criminal offenses or to your religious preference, for instance, and so forth. So you have to have a legal basis. It can be, for instance, the consent of the data subject. It can be when you have to comply with a legal obligation, and this legal obligation imposes you to process personal data. So there are 6-7 situations depending on the case. That's the first check to be done. Then a test that we execute each time we review a draft bill is the proportionality test, and it's combined with the necessity test, and it's linked to what we call the minimization principle. What is this all about? Well, we check that, for instance, when we receive a draft bill, all data which are processed under this draft bill are absolutely necessary for what we want to achieve. So for instance, let's say that a draft bill creates a process whereby, for instance, for registering students in a school, you are asked the name of the student. Well, it looks fair. The age or the birth date of the student, okay, that's still okay. Now, for instance, let's say that you have to provide with the weight of the student. We will certainly react and say, well, there is absolutely no necessity and then no proportionality for asking a student his weight to register in a given school. That would be an application of the minimization and proportionality principle. So we check, in other words, that all data which are processed, gathered, stored, are absolutely necessary for the purpose for which they are processed. Now, transparency is also something that we check from very close. We want to avoid that the state process data without citizens to be aware of that. We consider, and that's one of the main principles of GDPR and data protection in general, that all processing of personal data have to be transparent. People must be aware. It's not that you have to ask them their consent to process their personal data each time you want to, but they at least should be informed. And what should they know? They should know which data are processed by whom, what for, how long they are stored, and whether they are provided to third parties, and in that case, for which reasons. So the basic rules, why are my data processed by whom, and where can I find additional information if I want to, for instance, exercise the rights that I have in relation to those data. That's a good transition to the next point. We also check, but usually the details are not provided in draft bill, but it's still a very important principle of data protection law, which has to be taken into account, that the citizens must be able to exercise their rights. And you perhaps know that their rights, what are these rights? It's the right to access your data, to know who is processing your data, which data, what for, and so forth. You have to, in case you doubt that those data are necessary, you have certain rights, like for instance, asking that your record be deleted, or that some data are not processed for certain purposes. You also may ask the addition of certain data which would reveal incorrect, and so forth. So we are very, very keen to check that those rights can effectively be exercised. Data securization is also one of the most important principles, and if you look at the recent decisions of all European DPAs, you will see that there is quite a substantial part of these decisions which relate to the lack of appropriate securization of data, often leading to data breaches, but not always. Very often our homologues in other countries find out that some data, sensitive or not, are not sufficiently protected from theft, loss, amendment, and so forth. And last but not least, of course, you all know that data which are not necessary anymore for the purpose for which they have been collected should be deleted immediately. Now, moving on to the next slide. What do we do exactly when we revise, when we control the content of a draft bill? Because the previous slide was more, what are the principles of data protection that you should always keep in mind? But here it's more about, well, what do we do at the Knowledge Center of the Belgian DPA when we review a draft bill, let's say a bill? First of all, we are always in a situation which you will find under Article 6.1 C or E of GDPR, meaning that the bill creates a legal obligation, or creates a data processing which is based on the public interest mission of the authority who will be processing the data. In other words, we will never review a bill where the data processing relies on people's consents, for instance. It's always Article 6.1c or E, which is applicable here. Now, in those situations, what we very often point out in our opinions, because these are the pain points of the draft bills that we review. First, the processing of personal data should be defined in a very clear and precise legal instrument. Why? I mentioned transparency, and that's one application of the transparency principle. The citizens must be able, when reading the laws of the country, to understand which data are processed by whom and for what. And that's, we also traduce this by saying that the data processing should be foreseeable. And what does that imply in practice? Well, it means that for this data processing to be foreseeable for citizens, that some essential elements should be defined or described in a law. And what I mean by law is, in Belgium, it's what we call a bill, a loi, a wet, a decree, or ordonnance. These are, well, a bit the same words to refer to different acts taken by different parts of the or very complex authority system in Belgium. But it means it's the highest norm in the Belgian normative pyramid, would I say. So what we want to say is that a minister, for instance, can enact what we call a ministerial decree, but it cannot decide alone that it will put in place a very intrusive database, for instance. It has to be defined in a law, so the highest norm in Belgium. Why? Because we consider that the parliament, the member of the parliament who are voting these kinds of law, should have the words, the power to say, yes, we agree or we don't. So there must be a discussion at the Belgian parliament level or at the local authorities parliament level, but not, it cannot, this kind of data processing cannot be decided and imposed at ministerial level. And what do we want to see in those highest norms? First, the purpose of the processing. So why does this norm create a data processing or put in place a data processing? And if it's possible at this stage, but it's not always the case, we ask also that the identity of the data controller be mentioned as well. What do we also ask? It depends. When we realize that the bill is creating a kind of intrusive data processing, let's say, for instance, it's about collecting your DNA, or it's about creating new forms of control. For instance, social security related controls, or control of your wealth, this kind of thing, then we consider that additional essential elements should already be foreseen in that very high level norm, which we call here a bill. And what are those elements? Well, the data subject, so who are we talking about? The categories of data who will be processed, the retention duration of those data, identity of the controller, but we already mentioned this one. And in the case where it's about creating a new warehouse, as we call it, so a new central database, which is very intrusive, of course, we also ask the identity of third parties receiving access to the data to be mentioned, because we consider that it's important for citizens to know that even though the database is located, for instance, let's say within a particular administration, if other entities of the state have access to this database and can use the data stored in that database, it can have very heavy consequences for them, so they should be aware of that and informed of that. So in practice, it should be referred to it should be mentioned in the draft bill. Now, what do we also point out in our advice and check into our bill review process? I just mentioned that, yeah, we check that the data processing is defined and created by the right kind of normative text. And I mentioned it should be sometimes in a bill, or sometimes we can use a very basic arrêté from a minister, but it depends. And as I mentioned, when the processing is intrusive, we want yes, we leave no room for ministers to decide on this kind of processing. Now, what we see very often, the problems that we see very often in when reviewing draft bills. For instance, the purpose, so the reason why the state would like to process some personal data, the reasons may be very specific and of course legitimate, but sometimes what we see is the purpose are very general. For instance, say for the purpose of exercising our missions. And this is, of course, not specific enough. So we want the drafters of the bill to be more specific and explain, yes, we need those data to do exactly this. So they have to demonstrate why the data are completely necessary to to carry out the mission. So it's linked to the second point. The mission must be very clearly defined, and the categories of data and data subject as well. For the rest, I already mentioned this, that the identity of the data controller, the data retention duration, all these elements should be defined in the law. It's very difficult for me, Victor, to go to the next slide. I don't know why. Okay, I found a way. What we also check on a case-by-case basis, and it's very depending on the type of text we have to review, is the transparency purpose, as I mentioned. For instance, in the framework of the tracing situation and tracing text that we've been reviewing, it was not very clear for us how citizens would be informed of the fact that their data would be processed for tracing purposes and how. And if you look, for instance, at the website of Cienzano, who is the Belgian health institute in charge of managing the wide database of traced people, would I say, there is nothing on their website. So that's a question that we made. How are people supposed to be informed of all data processing which are made of their data if there is already nothing on the website of the data controller? We also often recommend to proceed with an impact analysis, a DPIA, when we realize that the text that we review create a data processing with a high risk, which is not so often the case, but it happens. We also remind the drafters' attention to the need to enter into a protocol that's a Belgian specificity, in the sense that when authorities exchange data or provide access to their own data to another, either authority, either third party, generally speaking, they have to agree on a kind of agreement that we call protocol, in which they have to agree on all kind of things to make sure that the way the data are processed is safe. For instance, that's a kind of contract, like a subcontracting agreement, but not with a subcontractor, with a party to whom you provide the data for its own missions. We also repeat very often that when we have database in Belgium which are regarded as authentic sources, so unique sources of information, for instance, as the national registry that we have in Belgium, it's not allowed to duplicate those databases or to re-ask people to provide with some data or information which are stored into this database. You have, in other words, to use the information data who are stored in these authentic sources. The underlying idea being that there are no errors and no faults when using the source information, the source database, where to the contrary, you might have diverging or old versions of documents provided and so forth. And so we want to make sure that when there is a source, it's used by all entities of the state and there is no duplication of information. Something that we very often have to remind as well is that a draft bill cannot just copy paste a part of the GDPR or just mention something like, well, the authority XYZ will process the data in accordance with GDPR. Well, it's obvious, it's an obligation, it does not bring anything, it has no added value, and it's a repetition of GDPR, which is expressly forbidden by the GDPR itself. So that's a bit to give you. I know it's it's a crash course. It's difficult to realize what we do in practice, but I thought it was useful to give you some insights as to how we evaluate the compliance of a draft bill, text, or decree, because we will enter into so much details by the tracing apps related bills, and it's important to understand which eyes we put on this kind of text. Now,
Let me ask a quick question for the audience.
yes.
When it comes to like general critics of the projects in general, without regards for tracing systems, what are the most common breaches that you meet?
The most common breaches.
Or others?
Yeah. The most common breach, very often the purpose is not specific enough. So as I gave the example, we see something like to be able to execute the mission of. No, what we want to say, to be able to, for instance, identify or make sure this person is really the one he pretends to be. There is a very big nuance between just saying, well, this is my job, so I can basically use all data I need, and saying this is exactly the purpose I want to achieve in the framework of this very specific regulation. To go back to the example I gave, registration of a student within a school, you should say, well, to proceed with the actual registration of the student in the school, and perhaps make sure he is not registered in 5 different schools for the same year. That could be a purpose. That's why you want to have his full identification data. You want to make sure that the student is only registered once. He cannot, like forum shop, register in 5 different schools and then make a choice on the 1st of September. So you could say, for instance, yeah, I want to make sure it's the right student, so I want to identify him through his national number. But if you just say, in order to manage school administration in Belgium, that would not be specific enough.
Of course.
So that's something that's a pain point that we see very often. Another pain point that we see is, yes, the identification of the data which will be processed. Very often we see like, yes, the person will be requested to provide identification data, data pertaining to his revenues, and all data required to achieve that purpose.
Yes.
Or we also see, yes, all data that the authority might deem necessary. Or we also see the authority will be able to request the person to provide with, for instance, data pertaining to. So it's not exhaustive, and it gives the impression that the authority may request absolutely all kinds of data from a citizen, which is not. Well, then we are not able to test whether these data are proportional or not if we don't know the list of data which may be processed in that situation. I lost the presentation. I don't know if I'm the only one. I can't see the slides anymore.
Maybe, is it coming back like that?
Yeah.
You see it again?
Perhaps a last example.
And maybe,
yes, very often in terms of data retention duration, there is also a lack of justification of the chosen duration. For instance, we are just provided with information that the data will be kept for 10 years. And we have to ask the author of the bill to say, well, but why 10 years? Is there? We assume there is a justification for the choice of that duration, but please tell us, enlighten us. And we don't say necessarily that 10 years is too much, but it has to be linked to, well, for instance, there is we say prescription in French, but I don't think it's the correct word in English. A time frame after which you cannot go to court anymore. So you could, well, for instance, consider that 10 years is you have to keep data for 10 years, because if there is a case in court, you need to be able to retrieve and use the data, and that's fine for us, but it has to be mentioned. It's just not like I choose a time frame because it looks great. So these are the typical things that we review.
Maybe also, I was wondering, because that was a problem that we saw when it comes to tracing systems, a misqualification between controller and processor. Is it something that you see often?
We very often, we never see any reference to processors in bills or decrees, but we often have the feeling that the people who are drafting the bills do not understand what a controller is. And for instance, they know they have to identify the data controller, and they just say, well, it's the Belgian state, or it's they give a name, they give the name of an authority, but they don't apply the principle that the controller is the one who decides on the means and purpose of the data processing. So very often we have to repeat that and say, well, we will not make the choice for you. We don't say that the choice you've made is not correct, but please be reminded that if you mention that the data controller is the Ministry of Health, for instance, please check that the Ministry of Health really is the person, so the public person, who will, in the fact, decide on the means and purposes. And that's something that it's very difficult to advise on this, because we don't know. We are not in their shoes, so we don't know how it's working in practice. So we just remind them. We try to sensibilize them that they have to make this choice in function of those criteria which are were listed in.
All right.
I really lost the presentation. I'll try to.
Could you find it again? Maybe you should just click on the top right button.
Yeah, that's what I did.
Maybe people in the chat could tell us whether they see the presentation or not.
Something.
Okay.
That's strange.
Because I personally see it, and I see that Luca Pinelli says so as well.
They also, yeah. And I don't. That's strange.
Wait, I'm going to try to fix it. Okay, maybe you should put back your video and sounds, and should be fixed now. There seems to be some technicalities. So is the public seeing us properly, or are there still some problems? I'm going to try to reach Mrs. Jaspar. I'm sorry for the... Mrs. Jaspar, if you can hear us, maybe trying to put your mic on. Sorry guys, this is what happens when we have a direct event. Sometimes unexpected things happen. I just hope it's not going to be too long. We're trying to fix it as fast as possible. So we're still waiting for a reaction of Mrs. Jaspar.
I'm back.
Ah, there you are.
Okay.
We can see you, we can hear you.
I was
That's
kicked
perfect.
out. Okay. Now, yes, presentation is
All
back.
right.
Okay, I think it's okay. We are back. So after the question, I will just give you a short list so that it's not too boring of the opinions that we've been issuing in relation to tracing in Belgium. So as you can see on the slide, we've been providing 7 different opinions on draft, either decrees or bills or amendments to bills on contract tracing. So as you can see, there are two big types of advices, opinions that we've been issuing. One on the one side, those on the creation of a central database for what we call ordinary contract tracing, and I will explain just afterwards what it is all about. And on the other side, opinions that we issued in relation to tracing applications. So now, what do we mean by this? I move to the next slide. Yeah. So on the one hand, when we say ordinary tracing or manual tracing, what are we talking about? It's already in place in Belgium and in many other countries. And the system works as such. Let's say you have COVID-19 symptoms. You go to the doctor or you give a call to your doctor and your doctor tells you, well, you should pass a test. You pass a test and the result is positive. So yes, you are apparently infected by COVID-19. What happens? The result of your test is provided by the lab, directly into a central database. The central database is hosted and managed by Cienzano, and Cienzano is a public health institution in Belgium. And what happens next? There is a contact center, a regional contact center. We have 3 or 4, it's unclear in Belgium, of people who will be calling you. So an agent will call you and say, well, Mrs. ABC, we've seen that you have been infected by COVID-19, so I'm sorry about that. We would like to try to trace people with whom you've been in contact with and you might have infected. So they ask you basically to provide the names and if possible more than that of people with whom you've been in contact. So obviously the people you live with, your husband, your friends living in the same cot, as we say in Belgium, so in the same apartment, your kids perhaps, or the people you have been in close contact with, but also the people you've been visiting, perhaps the friends you had dinner with, or your colleagues in the office, and so forth. So you are asked to kindly provide these agents with the names of these people, and if possible, with identification data and more importantly, contact data. So their telephone number, if possible, their address, if you have these, and so forth. And what happens next? Well, the same agent of this contact center will call your possible contacts and ask them a few questions, such as, well, they will not necessarily tell those people that you are the person with whom they've been in contact with, but well, usually they will. The link will be quite easy to make, but not always. And more importantly, what they will do is tell these people, well, you have possibly been in contact with someone who, in the meantime, has been revealed infected. Do you have symptoms? Are you coughing? Do you have fever? And so forth. And based on the answer, they will adapt the scenario and provide these people, so these contacts, with recommendations. And those recommendations are, for instance, well, stay home, or go test yourself, or try to work at home and do not go to the office, and so forth. Well, the idea, of course, to block the contamination chain and to avoid that these people will themselves, if they have been infected by you, further contaminate other people. That's the ordinary tracing system, which is, again, already in place in Belgium. Just a nuance, in the situations where the person infected is part of a community, so for instance, a jail, a prison, or a university, a home for the elderly, and this kind of things, then there is a nuance in the process, in the sense that the contact center will not be contacting any individual with whom the person has been in contact, but one single person within that institution. For instance, the health responsible person of the jail, and ask this person to take care of, yes, protecting the others, isolating some people from others, and so forth. That's an indirect channel which is used in those situations. Now, the second kind of tracing we are very often talking about is not yet in place in Belgium. It is in place in other countries, and that's what we call the tracing via tracing applications. So as its name indicates, the idea is that the owner of smartphones or mobile telephones can download an application. And how will this work? In practice, the application will be on your phone, and if one day you are detected as infected by the COVID-19, you might decide, so you don't have to, you still have the choice not to activate the function, but you might decide to activate the function whereby people who have been in contact with you over the last days for more than 10 minutes, and where the contact was at less than 1.5 meters from between you and the person, those people will receive a message generated from your mobile phone. It's a system of keys, and those keys generated by your phone will generate a message on their own device or their own telephone. Of course, the message will not be, where, dear Jack, you have been infected by Jane, but it will be, dear Mrs. or Mr., we have to inform you that you have been in contact. We will not tell you when, how long, and where, but you have apparently been in contact with someone who has been infected. So you don't know whom, you don't know when, you don't know anything. So normally you are not able to re-identify the infected person. And that's very important. That's the tracing via applications. It's in place, as I said, in many countries. It's also discontinued in certain countries. I don't know if you read that, but in Norway, they have canceled the application yesterday. In Great Britain, it's also questioned. So it's very sensitive. It's, of course, relatively intrusive, but to be honest, a good tracing system via an application seems to be much better than a system as the one we have for manual tracing in Belgium. In 3 words, and that's a personal comment, of course, the system to be put in place via applications normally does not reveal any information, any data as to any person. The data are fully anonymized. The only information that you get as a user is potentially that you have been in contact with someone who is infected. You are just not able, as I mentioned earlier, to retrieve the name or any other data as to this person. Of course, not his mobile phone number, because that would be too easy as well. And the data are not stored in any central system. It's Bluetooth. The data are just gathered and stored into two equipments, two devices. There is no localization, so it's, from a privacy perspective, relatively safe. Of course, there are always risks. There are always hackers who are able to do amazing things. But if you follow good protocols, and some good protocols exist, it's relatively safe and privacy friendly. The other advantage are that the system is almost free. Of course, developing an application has some cost, but it's relatively low. And there is very, very little room for errors, in the sense that it's one system, one device talking to another one. Now, moving to the manual tracing system, first of all, it's extremely expensive. I've heard figures like 200,000 euro, 200 millions of euros, sorry, in Belgium, which is of course a lot of money. And well, it's not working very well apparently. If I read the press, it's, well, the results are not very satisfactory. And more importantly, for our debate today, it's not super efficient, in the sense that you have to remind yourself who you've been in contact with over days and days before. So first of all, you might not remember who you've been in contact with. You might also have been in contact with people, but you don't know their name, or you don't know their telephone numbers. You don't know how to contact those people. Let's say, for instance, you are queuing at the bakery to buy some bread. Of course, you don't necessarily know the names, and even less the telephone number of the person who was queuing just before or after you. And you have been in contact with these people for perhaps 20 minutes. So in terms of efficiency, I'm not really convinced by that system which exists now. Now, I lost the presentation again, but okay, I'm back on the presentation, and I suggest we move to the main issues that we've been raising in relation to each of these two tracing systems. I will start with the call center based tracing system, the ordinary or manual tracing system, as we call it. First of all, the draft bills or decrees that we reviewed were absolutely not clear as to the purpose of the tracing. So, of course, we now all know what the tracing is all about. We know why we would like to trace people. We understand how it will be done, but it was not clear, in the sense that there was no link between the data who would be used and the purpose for which those data would be used. It was kind of a ball, and the text will tell us, yes, we will use this and this and this and this and this data, and there are three purposes. And the purposes were, first, calling infected people, okay, calling people who have been potentially in contact with infected people, and research. These were the three purposes. But it was not clear which health-related data or ordinary data would be used for each of the purposes. And for instance, there are very sensitive health-related data which are absolutely not necessary for tracing people, who would be collected and put in that database. And for us, it was completely questionable whether those data could legitimately be collected and stored, in the sense that they are not needed for tracing. So if we want to store those data for research purpose, let's say it. Let's write it down, let's confirm that, and let's be honest as to that fact, and not like let people guessing, yes, which data will be used for what. There were also no details as to the working of the tracing system. So the text was very rapidly written, apparently. The people were in a rush. And they would just say, well, we will contact people who are infected, and we will contact people who are potentially in contact with those infected. But it was not clear whether those second category of people, so the contacts, what would be told to these people? Would they have a choice to say, no, I don't want to talk to you? Would they have would they be called and called and called and again until they can't bear it anymore, and they provide you with an answer? Would they be contacted by phone, by email? Was it contemplated to send agents home, so to their domicile, if they don't pick up the phone, for instance? All of this was a black box. It was just, well, we will contact those people, but how? No details were provided. And also, it was not clear which kind of questions they would get, which kind of information would be collected, in other words, from those people, and more importantly, whether they would receive just recommendations. So, well, if you feel symptoms, please don't wait, go to your doctor or go for a test. No, that's one option. But when you were reading the text, it was also possible that these people would receive injunctions. So obligation to auto-isolate, for instance, not to go out anymore, or obligation to pass a test. It was not clear. Would they receive just, well, advisory piece of advice, or more yes, obligations to act, to do something? It was also not clear whether they would be controlled, in the sense that, well, let's say an agent would tell someone, you should really go for a test because you have symptoms, now it's time to go. Would the agent call the day after and ask for the result of the test, or not? Well, so the follow-up was absolutely not clear. It was, I think, at that time not clear for the drafters how the system would really work. And of course, from a privacy point of view, it's important, because we are not talking about the same thing. Just providing some people with recommendation is very different from telling them, well, I force you to do something tomorrow, and if not, be careful, you will, I don't know, lose your indemnity or not be able to claim for money back if you are in hospital within 2 weeks, and so forth. So the consequences can be very dramatic, and we thought it was really important also for transparency purpose to provide with a much more detailed explanation how the system of tracing would work. Sorry. We also questioned, and that's one of our biggest concern, why it was contemplated to create a whole new central database. When we look at the Belgian system, we have regions and communities, and tracing is a regional competence. So we have 3 regions in Belgium dealing with contact tracing. So each region has its own contact center, meaning that each lab is normally, I mean, it's how the system should work for me. Each lab would provide with the data, yes, this person is infected, to the contact center in charge of contacting people in that region. So we don't understand why the labs should provide any information to all 3 contact centers. There is only one, by definition, who will contact the infected person, and then the people with whom he or she has been in contact with. So the creation of a central database is, according to us, contrary to the minimization principle, because it means that 3 contact centers have access to a database with tons of health-related data pertaining to hundreds of thousands of individuals, with no justification for that. And don't forget that once the contact center have contacted those people, they also fulfill the database. They put additional data into that central database. And which data? Well, the result of their calls, or have they been in contact with the person? What was the answers? Well, did the person say, yes, I'm gonna go and test myself, or did the person say, no, sorry, it must be a mistake, I've never been in contact with anyone, I stayed home for 3 months? So it's additional data which is added into that central database, which becomes a very, very wide and complete database. So we don't understand why it is needed when you can do exactly the same at a smaller scale at the regional level. It's also very important, and I check whether I put that on the next slide. Yes, that for us, the database can be quite restricted in the sense that you just need contact tracing information. So that person is infected or presumed to be infected. That person is a contact of an infected person, and this is the recommendations that we've provided to that person, and these are the information provided by that person. And instead of that, this massive national-wide database is fulfilled with additional data such as your national security number, the national registry number, sorry, and other links with, for instance, your unique patient health record. And the first bills that we reviewed were mentioning and other possible data which might be needed. So the list of data which would be stored in that database was not exhaustive, and we do not understand, and still today we do not understand why we want to add these unique identification numbers and other health-related data into that database. It's absolutely not required and needed for tracing purposes. So if there is something else we want to do with this database, let's say it. And now we believe we understand what is the idea behind. It might be that the database is in fact a database constituted for research purposes, and it's linked to one of the three purposes, which was not very clear. We understand that we want to take the opportunity of the tracing system to create a very wide host database to allow labs or research center to try to find a vaccine or a drug, which is a good thing, of course, but let's say it's from scratch. Let's inform clearly citizens about that. And that's very important. Let's give all labs and all research centers the opportunity to use that database. And if you look at all bills or decrees that we've been reviewing so far, it's not the case. The bill says that the database can be used, so can be accessed by certain researchers, including Cienzano, which is apparently so that the health organization in Belgium, they also have a research department, and that's fine. But they also say, yes, there is a special committee which will decide who can have access to this database, under which condition, and so forth. And that's not in compliance with GDPR, which there is a whole chapter in GDPR, as you may know, as from Article 89 and after, which deals with research and says, well, basically, for research purpose, personal data might be used, but you must follow certain rules. And the main rule is what we call the cascade. And it says, yes, if you can achieve the purpose of your research with anonymized data, you have to use anonymized data. If you can't achieve that purpose with anonymized data, you have to motivate, you have to explain that, and then you may use pseudonymized data. The difference being that anonymized data, the link with the person is cut. You will never be able to re-identify the person. If you process pseudonymized data, to the contrary, you can rebuild the link with the person, because the link with the code given to your data is linked somewhere else with your name. So there is a way to reconcile your name with your data. So it's more intrusive, of course, because somewhere there is someone who is able to say, well, these medical records are those of Victor, for instance. So you have to comply with this cascade principle, and that's not foreseen in the bills that we reviewed. And the principle of the bills that we reviewed is, yes, the data will be pseudonymized, but never it's never said that they will be anonymized. So that's first problem, because if anonymized data is enough, anonymized data should be processed and not pseudonymized data. And the second problem, as I mentioned earlier, is that health-related data collected in the framework of tracing in Belgium should be available to all labs, all research centers, and not reserved to some of them upon decision of a specific committee who will decide based on, we don't know which criteria and what for. Research should be available to all parties. Now, trying to move to the next slide. That's okay. Now, as far as the second system is concerned, so the tracing system via applications, I will first give you just 2-3 insights as to the EDPB guidelines. The EDPB is the European Data Protection Board. So all European data protection authorities are member and part of this committee. And one of its competence is to enact guidelines. And guidelines, it's like when we at the Belgian DPA, we issue recommendations. At the EDPB level, we try to harmonize our recommendations so that the rules are the same in all countries. As you know, GDPR, one of the biggest main principle of GDPR is that the rules should be applied the same way in all countries, in all European countries. There are a few exceptions where a state can decide and make some choices, but generally speaking, we want this to be an harmonization text. And the text is one thing, but the guidelines who go a bit more in depth and provide some more detailed recommendations are taken at EDPB level. And at the moment where it was question of starting working with tracing apps in all European countries, we decided together, well, in the framework of the EDPB, to issue those guidelines to make sure first that all European countries would speak with one voice, so that Belgium would not say something and then France something else and Italy another thing. We really wanted to say the same thing, and we really wanted to to impose the same specifications for tracing apps. Why? Essentially because we all agree on the fact that tracing apps should be interconnectable, so that the Belgian app should be able to interoperate, sorry, that's the word I was looking for, to be interoperable. So the Belgian app should be interoperable with the app from France, if there is one, and with the Italian app, if they choose to have one as well. So we said, well, the specifications should be harmonized as well. And that's why we said, yeah, there are some principles. I invite you to read the EDPB guidelines. It's a 3-page document. It's very clear. It makes a lot of sense. And it really gives the basis of what an application should take into account as main principles. So what should an app developer be looking at when developing such an app? And the main principles, because it's kind of a long list, but the main principle is first that the adoption of the app should be voluntary. So you could not, for instance, say in France, well, everyone who is older than 10 years and younger than 80 should install an app. That's not fair, and this is not okay under our EDP guidelines. Well, it's not realistic neither, because not everyone has a smartphone. Not everyone is able to use a smartphone and so forth, but that's really the main principle. You should remain totally free to use an app. And it also means that you should remain free to stop using an app when you want. So for instance, let's say you use it, you download the app today, and after 1 week you say, no, I don't want to use this anymore. you should have the free choice, the right to say, I stop, I quit, I deactivate the app, and please delete my data. I don't want my data to be stored somewhere and reused. And the second very important consequence of this is that, for instance, your employer cannot force you to use the app, because it was contemplated at some point. Some large companies said, I'm going to impose the use of the app to all my workers, so that I'm sure it's working within the company and we can counter the propagation of the virus within the company. So that's not okay. Very important also is that the data gathered in the framework of the use of the tracing apps should only be used in that framework. It cannot be that, for instance, Belgium would say, yes, via the apps, we will collect some data and we will store this data in a database and we will reuse the database for other purpose. Is it not okay? Unless, of course, you ask the user of the app whether they agree to that the data gathered via the apps would be reused for another purpose. But you cannot package both and say, well, if you use the app, you should agree that your data will be used for this or that. It should be clear and granular, and the choice should be open for all options proposed by the app. Data immunization is important, very important, in the sense that what EPB said as well is that the tracing apps cannot use geolocalization. Why? Let's say, for instance, that I'm told, my phone is told that I've been in contact with someone yesterday at the bakery, and I've seen only one person at that bakery, the seller, for instance, the baker, or there was only one person in the room. So I can immediately retrace that the person who infected me was the person with whom I had a chat at the bakery. So no geolocalization. It should be totally free of any localization data. The data used and stored by the app should be minimal. So again, I should never be told that I was in contact with someone who I was in contact with someone for 1.5 minutes or for 10 minutes and 27 seconds, because all these data would possibly allow me to re-identify the person who infected me. And that's really the underlying idea. All data allowing you to try to re-identify the person who infected you should not be provided, should not be processed. That's why it's work also with pseudonymous identifiers. So I'm not, if I'm using that app, I'm not Alexandra, I'm AB1234ZB. Very important as well. The information should only be stored on my device, so no central, no exportation of data of the keys and all this data. It should be just between the phones using the app. There should be no centralization of the data somewhere. And of course, I mentioned that everybody should have the free choice to stop using the app and to ask for the deletion of its data. But besides this, there is no reason, of course, to keep storing the data after the pandemic. So after the crisis, all data gathered and stored during that process should be deleted from any device, any system, any protocol, and so forth. That's a summary. There are other rules, and again, I invite you to read the guidelines, because it's a very interesting document. But just a few last words. The EDPB says also that the apps should be regularly audited, because we all know that we are in a very new situation, that we could consider today that an application is an excellent one, and then realize that there are some risks that we were not able to identify as from scratch, which revealed or which happened, or so audits should regularly be processed, and it's also very important for each app developer, and certainly for the national authority who would make the choice of a single app to proceed to perform a DPIA, so an impact analysis, because we consider that in any case it's a high-risk processing. So one of the situations in which the DPIA has to be carried out. Now, the issues that we spotted in relation to the text, whereby it was proposed, or it was the use of a tracing app in Belgium was contemplated, are that the Belgian app, at this time we were still talking about Belgian applications, because it was still contemplated to have one application chosen by each of the regions. So we would live in Belgium with 3 different applications. Now the last thing I hear is that there would be only one, which is a good thing. But what we were told at that time was that the applications would have to rely on a given protocol, as we call it, but it was not giving, well, the text were not giving any details as to this protocol. So it was very difficult for us to assess whether the Belgian system was compliant with the Edp guidelines, because we were not provided with any details, or only with very few details about the functioning of the system. We found out, because we asked the question, that these applications would rely on the Dp3t Protocol, and we think it's a very good one. It has been put in place by experts from different countries, from different specialities, and we trust it's a very good protocol, but we found out that it was certainly useful to mention that this protocol was the basis of our Belgian system, and to mention its specifications. For instance, the fact that it works, that it relies on Bluetooth, that the data are decentralized on the device, so that there is no central storage of the data, and so forth. What we found out reading the text, and it was not obvious, so one of the remarks was also that it was very difficult to decipher the text, but we realized that even though the apps were apparently good, well, the protocol for developing apps was good, the Belgian government had in mind that the data from the apps would be exported into a central database. And as I just mentioned, it can't be the case, because we create a whole system to avoid identification of the users. So it can't be that besides this, you export the data from the devices, you centralize them in a database where you make the link with the telephone number of those people, because of course you re-identify, or at least you make it possible to very easily re-identify the user, so both the infected and the people who receive the message that they have been in contact with those. So we were a bit surprised to see that, well, we start with a very good basis, a very good protocol. We follow the principles developed by EDPB, and then at some point we kind of forget all this main and fundamental idea that people cannot be identified by injecting all their data, not anonymized anymore, into a central database. So we found that there was a very, very big issue with that. I don't know where we stand with this, and I really hope it has changed in the system which is currently developed, because this would be really a pain point, a very important problem for us. Yes, I think we put we were very insisted on was that when we said the adoption of the app should be really voluntary, what we wanted the text to mention specifically that no single pressure could be exercised on someone for installing the app. And for instance, you could not say, well, if you shop into my mall and you use the app, you get 20% on all your purchases. Or if you shop into my mall and you install the app, you can come every day. If not, you can only come on Tuesday, for instance. So it also means that no kind of pressure could be put. Otherwise, consent, while the voluntary character of the application would not be safeguarded. We also realized that the Belgian government was not apparently contemplating the publication of the source code, or at least not of the entire source code. So we said it's really important so that experts, specialists can really analyze the source code and perhaps find out some failures. And that, well, again, I said all of this is new, so problems, issues are possible, and we should be able to detect them as soon as possible. And how can we do that? By publicating the web source and allowing, well, the public as a whole to check whether there are issues in the source code, which certainly can be remedied before the system is further used. Now I see I'm at the end of my part, and I will give the micro back to Victor, who will tell us about the ELCSE guidelines on tracing apps. So as you can see, everyone has been providing with its own guidelines. A very good thing, what I said to Victor before, is that hopefully we all say approximately the same, which is a good news. So it gives the idea that, well, now the rules for developing compliant tracing applications are really harmonized. There is a kind of agreement on those rules. So I think if we want to develop an application today, we can't say, well, we don't know how to do that. Oh, sorry, we were not informed. I think the rules are really clear and make much sense to me.
Thank you very much for the presentation. Just maybe to sum up what you said, at the end of the day, with all the information all the documents you could read, all the everything you had access to, all your assessments, today, what would you consider as the best system at the end of the day, from your perspective, before jumping to ELSA Belgium's guidelines?
Try to take the micro back. The best system for me would be to have in Belgium one single application based on the Dp3t Protocol, scrutinized by a panel of experts from, well, very different institutions, so to make sure that there is no pressure, there is no advantage given to either a community or a research center. So to have some kind of audit panel reviewing all applications who are proposed, because some developers have developed very, very good applications. And I think it's very important to have an independent and very representative panel of people looking from very close at any application submitted and choosing the best one. Just one, I think that's key in Belgium. Of course, able to interconnect with other countries, certainly on neighbors like France and Netherlands applications, if they decide to use one. In France, it's already the case. Regular audit, as we mentioned, I think we should really put in place a process whereby the application is regularly audited or even constantly audited by the same experts or even additional experts. Transparency is really key. So it's very important that each screen of the app reminds users that they have the right to stop, that they have the right to say yes for this, but not for that, for instance. And a purely decentralized system where all information is only stored on the user's device with no centralization, no exportation of any data in a central database, because that's for me the failure of the system. And as you all know, trust is key, because we need to have as much people as possible using those apps for the system to work. And if you want to have trust, you must be able to look people at people into their eyes and say, your data are only stored in your device. They are not centralized. No one has access to the information. You are infected, you are not. And it's up to you to decide to share that information or not. That's for me really, really important. And then under those conditions, I think a tracing app is much more interesting, efficient, and privacy friendly than the current tracing system via call center, which is for me, well, apparently, and I'm not the only one thinking this, a bad system.
Yes, and that's actually the very first point we try to address in our guidelines, which system to choose, which is kind of the basic questions here. And we agree with what's being said. This is actually not everybody's opinion, that tracing apps are way more efficient than call centers. The only problem, of course, is that they need to be used by a certain percentage of the population, which is evaluated around 60 or 70% of the people. And this is very hard to get there. And we see it in France at the moment, where the Stop COVID is being kind of a complete failure because of the lack of download. And I think, and from that point, and from also something that you said in your opinions, we kind of agree with the fact that both are needed. Call centers and apps are today needed because it's not possible today to kind of impose the application to everyone, to impose everybody to use it, and that would be way too intrusive. So today, because applications are not implemented in everyday life in Belgium, like not tracing applications are not implemented in everyday life in Belgium, call centers are still necessary, but they might be integrated in a whole framework, in a fully integrated framework. And that's, if I'm not wrong, something that you said in your opinion about the royal decree about tracing apps, that in order to be proportionate and necessary, tracing apps need to be fully integrated in the whole framework of fight against the spread of the virus. And this is something that is central for us. And from this idea, from this conclusion, we believe that applications in call centers should be used, call centers being still a default system, while the applications should be encouraged. And encouraged in a smart way. For example, by making it a way not to have to go through the processing by call centers, which is way more intrusive because the list of data collected by call centers is truly impressive with comparison to that of the apps. And so downloading the applications early enough before being infected might be a way for the person not to have to go through call centers, which would allow the person to have a way lower, in theory, a way lower processing of their data. But both need to be integrated with one another. You cannot just say, okay, we have the apps on the one side and the call centers on the other side, and everybody who's infected, if they are infected, and even if they have the apps, they're going to go through call centers. This is kind of a nonsense, and this is discouraging the use of the apps, kind of. And so this is why we believe that both should be used in parallel, with applications being a way to, let's say, escape this default system that call centers are. So this was one of the main and most central points we had to address in our guidelines, and this is actually the first we discussed. And then we tried with maybe to give some introduction about those guidelines, because I'm moving a bit too fast forward. So as Mrs. Jaspar said, we believe that discussion and plurality of opinions is a central point in this debate, and we wanted to help the Belgian authorities make the right decisions. But we wanted to do this still being fully neutral politically. We didn't want to take any political position, let's say. So we decided to give an objective juridical, an objective law-based opinion, which we gave by analyzing very deeply the advices given by the Commission, the European Parliament, the European Data Protection Supervisor, the Council of Europe, of course, the EDPB, and finally, and naturally, the Belgian DPA. And from all that, we drafted our own opinion, which is sometimes slightly different from one or the other advice that's been given, but which is in the overall pretty much a gathering of everything that was said before already. And so for that reason, I'm not going to go too much in detail in everything that's been said. If you want, so you can find them back on our website. You will find the link to them, I think. There it is. All right. So yes, to come back on what those guidelines say. As I told you already, we believe that both call centers and applications are needed and that the use of applications should be encouraged. This notion of encouragement, of course, is to understand with the basis of that processing, which is consent, which means that you cannot just say, okay, a person who goes to call center is going to have some more taxes, is going to be forbidden to go to that or that place. But we still believe that it's not against this understanding of consent to give positive incentives to the use of applications, such as reductions, vouchers, for example, which is a very common way of encouraging some habits, some new behaviors. So this is how we kind of see this system. When it comes to the second point, once again, I'm not going to go through all the purposes, scope, duration, deletion, but there is something that I would like to talk about, which was absolutely not mentioned in the different royal decrees, at least those that I could read, because one of the problems in this whole discussion in Belgium is that we do not have access to a lot of documents yet, since everything is still kind of being discussed. But something that we did not see was that there was no room for the processing of non-anonymized data for research on the basis of consent. Nowhere it's been said that a further processing could be organized by the different call centers, because this is mainly where this could take place, if the person consented to it. And we believe this should be put into the different legal texts. When it comes to the security, there are many things that could be said about that, because this point is, from our perspective, probably the most important, because the security of data is the one that ensures the trust of the population. And this is why this is absolutely central. Of course, what is needed is first an encryption of the data. Any data that would be shared from one database to another one that would be sent should be completely encrypted on an end-to-end basis with a state-of-the-art encryption, which means the most efficient encryption method at those days. For example, asymmetric encryption, which is probably one of the best existing today. Another risk, and Mrs. Jaspar already talked about it quite a bit, is the risk of cross-matching. Cross-matching is basically the ability of re-identifying a person with anonymized data, if the anonymized data is mixed with other data. So let's say you have a first set of data which you anonymize, but then still put back in another database, which would allow at the end of the day to re-identify the person. And this risk is very important when you collect so many data and you give it to a central authority in charge of keeping medical databases. So we believe that in order to avoid cross-matching, and this is something that's been stressed out by the authority, there is a true need to isolate all databases from one another, and especially those differentiating databases from coming from tracing systems and other databases that Cienzano could have, or even the different regions or communities. Another point which from our eyes was kind of missing, even though it's a question of good sense, but there was no specific date foreseen by the different decrees for audits. It was not said that the whole system would be audited several times at each period of time, which is obviously needed for trust reasons, but not only, also for security reasons, because the GDPR imposes some obligation to contact the data protection authority in case of breach, but those breaches might not always be obvious, especially with some very complex software such as applications. And without those audits, the risks are increased in a terrible way, which we think could be avoided if audits are foreseen on a regular basis. And this should be from our eyes, from our perspective, put in the law. Maybe two last points about security and securization. First being Captcha. So for those who might not know what Captcha is, Captcha actually is a software which allows for identification of the person, not identification, but the certainty that the person is not a robot, but a human. It's very often used, for example, when you try to connect yourself to download some files on the internet. And the problem with Captcha, and that was very well talked about by the French Data Protection Authority, is that there is one main actor on this market, which is reCAPTCHA. And reCAPTCHA is a software created by Google and dealt by Google, which means, and Google being, of course, an American company, there were some risks that at some point data might be secretly sent to America, which would not allow the European authorities to exercise a proper follow-up. However, I must say that this problem has been seems to have been addressed pretty well by the Belgian authorities, since the system that they chose is actually It's Me, which is some form of Captcha created in Belgium by a consortium of Belgian banks and communication services providers such as Proximus or Base, which would then ensure that their databases are located in Belgium and then kind of redress this Captcha problem. One final word on security, because this was not, apparently this had been clarified, that applications will be put into place by the different communities of the country, but nowhere in the decree was said, at least in the decree that was kind of published or accessible, how many apps would there be? This was not accessible, at least for us. And so we had this question, so what is an ideal system? How to ensure the right amount of apps? And we believe that the central point here, once again, is control. The ability to control the applications, to have access to them, to know that their source code is disponible for the state, that they are collaborating with the states, because of course having tracing apps that would not be collaborating with the state, for example, if the population wants to send their information for research purposes, this was a complete nonsense. However, that being said, we did not really see why we should limit us to one applications as long as they were offering a sufficient degree of securization and that a complete and full control was possible. And so we believed that a right way to organize that would be the creation of a label, the label being then needed to create a tracing application in Belgium. And this label should be given after a control by the DPA, after a control by technical experts of the state, would ensure that not only the security of the system, not only the possibility to control it, but also, and that is central, it's interoperability with other apps in Belgium and other apps from other European countries. Otherwise, once again, tracing, just creating a competitive market based on impossibility to interoperate was a nonsense on this matter. And so this is what we came up with. Finally, when it comes to controllers, what was said in the text we had access to is that only Cienzano would be controller, and all the other involved parties, such as app developers or call centers, which are regional, would be, yes, and all those other parties would be processors. And this has an important impact on a data protection point of view, because controllers are directly responsible for the data that are processed, while processors are responsible kind by impact. And the main instrument that is used is, as Alexandra Jaspar said, protocols. While actually, a controller is a person who is responsible for selecting the purposes and means of the processing. And if the purposes of the processing were clearly drafted in the law, more or less clearly drafted in the law, it was not the case of the means. where actually there was a very broad freedom of the different intervening parties. And from that point of view, we do not believe that considering Cinzano as the sole controller was a judicious idea. And we think that all controllers, by law, all controllers as understood by the GDPR should be considered as such, and therefore have their responsibilities and duties as drafted, as created by the GDPR. Last small question, the one of transfers. Of course, one important point, and this is what we try to talk about with the Captcha question, an important point is that all databases who would have access to the data must be located in the European Economic Area. Why? The reason is simple. It's because on those territories, the GDPR applies, and there is the possibility for the European Data Protection Board to exercise its jurisdiction in this territory. That was so. When it comes to transfers, it should be absolutely ensured that no transfer outside of the EEA would be possible. And the last point, and this was talked about by the European Commission, if I'm not mistaken, is that with the question of transfers of information to employers. And completely in line with what was said by the Commission, we believe that data should primarily not be sent to employers unless there are very, very strong reasons to do so. For example, if it is needed for the exercise of the profession, which is the case, for example, for doctor or nurse, but which is not the case for most of the professions. So those are a few highlights of what we said in our guidelines. But once again, you can find them on our website, and I would encourage you to read them, as well as the different advices and opinions that were given on the subject. Mrs. Jaspar, I think the opinions of the DP are only disponible in French, if I'm right? Or can we find them somehow in English?
They are all available in both languages, national languages, French and Dutch.
And are there going to be some in English, or?
No.
No?
We
Okay.
never translate our advice in English because we only, they are usually not looked at by people who are not Belgian citizens, and Belgian citizens are all supposed to understand at least French or Dutch. But no, we do not translate our opinions.
Okay. Well, so for the French speakers or Dutch speakers of our audience, I truly advise you to go read them. They are not that long, not 100 pages, but all those different opinions really help you have your own opinion on the matter. And I think this is important in such a central topic. And this is where I would like to conclude. The only thing I would like to say is that this debate might seem very technical, but we try to explain it today. And actually, when you go through the barrier of technicality, you might very well understand that there is room for debate. It might seem like there is only one solution, but it's not the case. This is a democratic debate, and I think everybody has their place here, and everybody could give their opinion. And this is very important for you to understand what is at stake and to defend the position that is yours. And this is where I would like to stop now. Ms. Jaspar, maybe would you have a few last words?
Well, a few last words. If you have, I don't.
in the meantime, let us check the survey that we have, and which is actually pretty interesting because everybody here, all the people who voted in favor of the app, which is surprising. So this is the many it seems that few people were actually more in favor of the app. So, in any case, let us, in the meantime, I'm not sure if things like problem, but in the meantime, we can already move on to the questions. There are some. So, I will activate the question mode. So, for those of you who have questions, it is time for you to ask them. They're going to be projected on the screen. We're going to try to answer those questions together. For those who are participating once again, the questions are, I guess, what we do. People will be more time asking your questions while you
All right, we're back.
Okay, I'm back. Well, just as a final word, perhaps, to tell you a few words on the status of the process. Well, I told you we've been reviewing 7 draft bills or decrees dealing with tracing in Belgium. Now, the status today is that some of these are applicable today, and they have they will be enforced until the 30th of June, which means that as from the 1st of July, there is a new text who is supposed to replace those existing bills and decrees. And this new text is what we call a cooperation agreement. So I mentioned it's an agreement between the federal state and the regions and communities, so the local entities. And we are supposed to review this cooperation agreement, so it should be our 8th opinion on tracing in Belgium, but we have not received the text so far, so I don't think we will receive it for review. And anyway, if we receive it tomorrow, it's not possible for us to issue an advice on such a piece of law in 3 days. So I'm a bit concerned in the sense that, well, the bills and decrees that we've been reviewing so far were still not sufficiently compliant. They were not providing with sufficient guarantees in terms of data protection. And I'm afraid that this new cooperation agreement, which has been negotiated, and I don't know who was in the room. I don't know if they have been counseled by data protection specialists. I don't know if there are some pressure which have been exercised. I don't know in which kind of urgency they had to work and so forth. So I hope sincerely that we will not end up with a text which is a copy paste of those previous texts that we've been reviewing, because we will have, as from 1st of July, in Belgium, a general text dealing with tracing, which would not be compliant with data protection. So if any of you hear of something about this, it would be interesting. Please let us know. I've been asking different people to let me know whether they have a view on the next step. Is it perhaps contemplated to postpone the adoption of this text, or are we still going to be unable to provide with an opinion on this? I hope so. But voila, that's the situation today, and I wanted to open your eyes on this and tell you a word. And that's, I think, my final word. So I can't tell you today whether the legal framework in Belgium for tracing will be a good one or not, because I'm same as you, expecting for some further news and hoping that we will still have the opportunity to provide with our advice on this.
Thank you very much for those words. And in any case, I don't know for the others, but I can assure you I'm going to read with a lot of attention the next advice that are going to be given by the authority and with a lot of interest. So we can move, well, for the second time to the questions now for those who have questions to ask. So I'm going to give everybody a little bit of time to ask their questions. And maybe because to let everyone a little bit of time to write, I might start with a small question. I think, and I'm sure I'm not the only one of the big risks of the consequential risks of the application is the risk of creation of a monopoly around research in Belgium when it comes to COVID-19, and fight against the COVID-19 and all the information that would be gathered thanks to tracing systems. How important, in your eyes, is that risk, and how can we ensure that this would not occur?
Well, the answer is very simple. If we want to avoid any monopoly on data which can be useful for research purposes, we should just not say anything, not state anything in the draft bills or decrees on tracing, because the rules are clearly stated in the GDPR. They are sufficient, and we do not need to add anything to these rules to allow labs or research centers to use those data for research purposes. What we should not be doing is adding additional requirements in the tracing bills or decrees, whereby we say, as it was the case in the projects that we reviewed, well, that only those who pass the test or receive a card from a committee XYZ can use the data, which should just suppress these formalities and these pre-tests for labs to access the data. It's not necessary, and this is a breach of the GDPR rules in terms of research, use of data for research purposes.
Okay, thank you very much for the answer. We have one question from Luca Pinelli. So, thank you very much for your presentation. A pretty hot debate these days regards Mr. Frank Robin, who, according to the newspaper Wilfried Magazine, has drawn up the royal decree fixing the conditions for monitoring contacts with patients of COVID-19 exercising an illegal mandate with the Data Protection Authority, and has also set up the Information Security Committee, going against the recommendations of the European Commission and the Council of State. Do you think these functions effectively constitute a conflict of interest? If yes, how this situation might be fixed and might be prevented to happen again in the future?
So I've read the question. The specific question for me is, do you think these functions effectively constitute a conflict of interest? If yes, how this situation may be fixed and might be prevented to happen again in the future? I read it again. Huh?
If you want, I can put it up for the first part.
Well, effectively, I read the Wilfried, of course, as well as the other press articles which were published last week or beginning of this week. The fact that Mr. Robin would have drafted the royal decree, that's also something I heard, and of course I was not sitting with him, so I can't confirm, but it's something which is, I think, confirmed, or at least that was written and said. Now, what I did to avoid a conflict of interest in this very situation, because Mr. Robin indeed has a mandate in my knowledge center, and it functions with me and 6 other people which are not employees of the Belgian DPA, but who are people from the society, I would say, representing all of the Belgian citizens. Mr. Robin is one of these, and to avoid any conflict interest in that matter, knowing, because that was told to me that he had been drafting the text, I did not send him the text for review. So how does it work normally? Normally we have hearings and we discuss text. So verbally, we are in a room and we have received in advance the draft opinions, and we make comments and we agree and we discuss and we take decisions. In this case, we were not in a room, of course, we were discussing via emails, because we were in a COVID-19 context where we could not meet. And the problem with these royal decree is that we had to issue our advice in a very short time frame. Otherwise, they would have taken after the vote, so our opinion would have been useless. So we did that very, very fast, and I did send the draft opinion via email. So we had no meeting, even via Skype, so no physical nor virtual discussion. We made that via email. And to avoid any conflict of interest in that situation, I did send the email with the proposed opinion in attachment to the other members of the Knowledge Center, but not to Mr. Robin, and he was, of course, aware of that. So in this very situation, there was no conflict of interest because he did not get the text, because I took the initiative not to send him the text. I don't know if it's an answer to this question. Now, it's true, because I read between the lines, there is, you talk about illegal mandate. It's another story. There is, in the Belgian law who creates our authority, there are some conditions to be elected as member of the Knowledge Center. And one of these conditions is that you may not have a public mandate. And so the question here is, has Mr. Frank Robin one or more public mandate which normally should prevent him from being a member of the Belgian DPA contact center? And that's, I think, what you referred to, the illegal mandate with the Data Protection Authority. And now the very last question: do you think these functions effectively? I don't know how this situation may be fixed and might be prevented to happen again in the future. Well, as I said, there is a law. This law who creates the Belgian DPA. It's very clear. There are conditions to comply with for being a member of the Knowledge Center. The only answer that I can provide you is let's comply with these conditions, and then we will have no problem of violation of incompatibilities, what we call legal incompatibilities, which are stated in the law. The law is okay. We don't have to fix that law. We don't have to change that law. It's clear. If we want to avoid these critics and avoid that members of the knowledge center are or are not in breach of these conditions, so access conditions for being a member of the Belgian DPE, let's just look at these conditions at the moment we choose them. That's the only thing we can do. Now there is also a process. I've read that yesterday in the newspapers. There is a process whereby Mr. Robin and someone else, I think as well, but I can't remember whom, they are interviewed at the Parliament on the 7th of July, I think, to to be requested to explain themselves on these conflicts of interest and incompatibilities questions, with a general question of is it normal that you sit in all these different bodies and can be, and I it's not my words, I use it, I read the press. Is it normal that you guys can be at the same time judge and parties? It's normal that you can participate into the setup of a system and at the same time have a seat in a body who is controlling that system. That's roughly speaking, I think what those two people, including Mr. Robin, will be asked to answer.
Okay, thank you very much. I think it was very, very clear. I'm going to let a bit of time for other possible questions. There's one here coming from Maria Anescu, which would not appear for some reason.
Well, I can't answer that question on Google, Apple, because we've not been analyzing these this system. Why? Just because it has not been considered in Belgium so far. When Minister Bakker and the Task Force Corona decided to look at an application, I was immediately informed that the Google App Standard would not be chosen. So we did not start investigating whether it was good or a bad system. So as everyone, I read in the press first what it's all about. But now, if we are requested today to have a look at it, we will do that. We will take our ICT advisor and make an in-depth analysis of the system. But today, I'm not able to compare, provide you with the pros and cons of those systems, because I did not do the exercise.
Okay, thank you. I'm gonna close the Q&A session now. There we are. Okay, well, Mrs. Jaspar, I think it's time for us to finish this webinar. I would really like to thank you a lot for your participation in it. I've got to say in the name of ELSA Belgium, that was a true honor to have you here today and a representative and future president of the Belgian Data Protection Authority. And I would like to thank you in the name of the whole association, but also on a personal level, because it was a true pleasure preparing it with you and presenting it with you. So really, thank you very much.
Thank you. Thank you, Victor, as well. It was a pleasure, shared pleasure, certainly. And thanks for the attendees. It was long. I hope it was useful and interesting. And thanks to all of you.
And thank you, of course, to the audience, indeed. Well, it's time for us to leave. And I wish everyone a very nice day. I will just give you the link if you want to check further the website of the Data Protection Authority. Okay, there we are. It's time for us to leave. And I wish you all a good afternoon. Goodbye. And
thank you for attending.